clients in all aspects of professional regulation. Naakai Garnette is the Director of the Professional Conduct Department, College of Massage Therapists of Ontario. Naakai oversees the college's complaints, reports, hearings, and compliance processes. Katharine Neufeld is the lead Discipline and Fitness to Practice Ontario College of Pharmacists. In this capacity, she assists in matters that have been referred to either the Discipline or Fitness to Practice Committee for a hearing. And finally, Melissa Everett Withers is the General Counsel, Nurses Association of New Brunswick. Melissa's primary responsibility is for complaints regarding discipline and fitness to practice of New Brunswick registered nurses and nurse practitioners. This is the Canadian network of, sorry about that, Melissa. So let's start, okay? We've done the intros, we got some of the housekeeping. We named this the virtual hearings discussion, okay? But I've heard it called different names. So maybe we can just start, what is a virtual hearing? Is it an electronic hearing? Is it a digital hearing? Let's kick this off, like understanding what we mean by virtual hearings. Maybe Naakai, could you start us with this, your opinion?
Thanks, Alyson, and good morning to everyone who's attending this webinar. Usually we refer to it as an electronic hearing, but I think that there are, as you've mentioned, numerous ways to refer to these types of hearings which do not occur in person. So for our purposes, we refer to a virtual hearing would be a hearing that might occur via teleconference, or more commonly a video conference hearing, but also a virtual hearing could be a hearing that occurs in writing as well. And the format or mode in which you would decide which mechanism or format in which that hearing would be based on the different circumstances of the individual cases.
Hi, yeah, good morning, everybody.
Go ahead.
Good morning and good afternoon. I would definitely agree. I think it's more than just video conferencing. It could be video conferencing, teleconferencing, it could be writing. It could be any combination of those things as well. I know also the rules for our discipline committee allow for taking evidence before the hearing, which is an interesting way to approach things if that's a way to address some or all of the evidence you have to deal with too.
And I think one of the main considerations when discussing virtual hearings and what type to use or what types to use, because I think it's quite right that you can use multiple types throughout a hearing to get the best result, is really looking at the individual case and what type of virtual method, so to speak, would provide the adjudicator and the participants with the kind of functionalities that they need to get it done, so to speak. That might involve taking into consideration people's technical capabilities, access, of course, to certain technologies that they might need and equipment that they might need, maybe something that we want to take into consideration as well to make sure that all participants have meaningful access to the hearing process. And of course, another thing to consider would just be, what do we need to do? Are there witnesses? Do we need to assess credibility? Is this something that can be is it a procedural issue that could be decided in writing? And really look at what needs to get done, and then pick the virtual, so to speak, method that works best for that.
Okay, thank you. Now that, as I said, we've called this the virtual hearing, hopefully maybe we have a little bit of understanding of what that means. Let me step back, and I've introduced the panelists based on just some of those description of what a virtual hearing is. Let me give you each two to 3 minutes just to share with the audience and the participant some of your experience or background and overviews of virtual hearings. I'm going to start with Alexandra. We haven't heard from you yet. Maybe you could start.
Good morning, everyone. So I was lucky enough to do my first electronic hearing by video conference a couple of weeks ago. That was a hearing before the Discipline Committee of the Ontario College of Pharmacists. The member in that case was self-represented, And I think thanks to a lot of the preparatory work that was done by the hearings department at the Ontario College of Pharmacists, my impression was that the hearing went very smoothly. So much so that I would be happy to do more hearings electronically even after the current circumstances have been improved, specifically for hearings that are uncontested or hearings that only require submissions to be made by the parties. I think it's a way of the future going forward.
Thank you. Anastasia, do you have some thoughts?
Yeah, so I think I've also had the opportunity to be involved in a couple of virtual hearings that have taken a number of shapes and sizes in terms of what they actually looked like. And I think that something that can be considered in this discussion and is really important is that the virtual hearing, so to speak, can actually apply to various stages and proceedings throughout the discipline process. So of course we have the hearing proper, but I've also had experience with doing virtual procedural matters, motions, adjournments, withdrawals, all that kind of thing as well. There's pre-hearing conferences, and all of these different things can be done virtually in this time of COVID. And I think I agree with Alexandra afterwards as well. I think as we do them and as we become more familiar and establish the processes that make them run smoothly, they really do kind of take some of the dauntingness away from it. And in my experience as well has been extremely positive. Any technological glitches that happen are generally sorted out quite quickly. So I've also had an overwhelmingly positive experience with it.
Excellent. Melissa, we haven't actually heard from you yet.
Yes, good afternoon, at least from the East Coast. We just last week conducted our first electronic hearing of a fitness to practice matter by Zoom. So we've only got the one under our belts, but we do also have, I mean, that's not what we're here to discuss, but we also do have written hearings, I guess you could say, at our complaints committee level, our sort of threshold committee that decides whether one might get referred on to discipline or to fitness to practice or in fact get dismissed. That's already done in a paper review. So there's to that extent, it's a different way of thinking about it, but we already do an alternative to an in-person hearing. And then we also have alternative resolution processes where a member may have the opportunity to make certain admissions and make a submission as to what an acceptable order might be, and have the complainant agree with that, and they can proceed that way. So we already do have alternatives to in-person hearings. It's just that we're not used to thinking of them that way. But yes, we did have, like Alexandra mentioned, I would say a surprisingly smooth experience with an online Zoom hearing technology-wise. And we'll talk, I guess, in a few minutes about some of the functions that really helped that go along. And I agree that it's certainly something that I think we're going to keep in our repertoire for going forward in terms of dealing with hearings both in person and then this way. And we'll just add that to the list of things that we're able to do to manage complaints.
I think you made an excellent distinction. It really is the alternate to in-person. It's not just the virtual concept. It's the alternate to in-person. Katharine,
Hi.
What's your experience? Yep.
So I share with Alex the experience of the uncontested hearing that we did together. And I fully agree with everything she said there. I thought it was very successful, and that I think is due, at least in part, to a lot of careful preparation that went into it. And we can obviously touch on that more later on if appropriate. Even before we shut down for COVID, we'd done parts of hearings in an alternative format. So we'd had witnesses appear by video conference, we've had members appear by video conference or teleconference, and we'd had done one discipline hearing fully in writing at one point.
Thank you. And back to you, Naakai. You started us off. What's some experience that you've had with the alternate to in-person hearings?
So prior to the COVID-19 outbreak or pandemic, we had limited experiences with electronic hearings. We have held parts of hearings via video primarily video conferencing for witnesses that are needing to testify remotely. We have had hearings in writing for motions, as well as a couple of instances where it was a teleconference hearing. And then since, and all of those, with respect to the teleconference hearings, they've always been for matters that are uncontested. And similarly, now that we are working remotely, we have held a few hearings via teleconference, as well as a couple of hearings via writing. And then in terms of the difference between the two and why decisions were made, primarily that was based on it being whether it was an open hearing, it being a discipline hearing versus a fitness to practice hearing, which is closed.
Okay, thank you. So you mentioned that we had the participants fill out. What are the key concerns that they're facing with? What are their concerns about doing virtual hearings? One of the major topics that was consistent across a lot of the responses was the legality of it. How do you ensure, after you've gone through this, that it's still legal, can stand up legally, the results from the hearing? And I just wondered, they talked about physical evidence. How do you manage that? The defensibility of the entire proceedings, any procedural requirements that might be necessary to make this a successful hearing, just especially when it comes to sharing documentation. Just wanted to get some feedback and input on learnings, best practices. Alexandra, any thoughts on that? Well, let's start with you.
Yes, in Ontario, the government assisted us by passing legislation specifically designed to facilitate electronic hearings going forward. That is called the Hearings in Tribunal Proceedings Temporary Measures Act 2020. And that legislation has broad application to tribunals in Ontario and allows tribunals to hold hearings in person, electronically, in writing, or a combination. Do so even without the consent of the parties. Tribunals can also establish rules in terms of how that's going to happen in practice. And we've seen that many colleges have gone forward with developing rules and proceeding with electronic hearings during this time. We've also seen the courts in Ontario, some have been quite progressive about forcing parties to proceed with electronic hearings. We had a case from the Divisional Court in Ontario, the Association of Professional Engineers and RU, where Justice Corbett required the parties to proceed with a hearing of a judicial review by video conference, despite that the respondent was objecting. So at least in Ontario, there's legislation to allow us to facilitate electronic hearings, and the courts have also been indicating that that's how they want to move forward during this time as well.
Another area.
Want to add? Yeah, go ahead, Anastasia.
Yeah, I was just going to say another area where, in terms of the legal considerations or concerns around choosing which kind of virtual hearing to determine, there's actually a fair bit of case law already that speaks to this, I think, because as Katharine and Naakai both brought up, this isn't an entirely novel issue. This was sometimes considered in the context of a witness who wanted to testify electronically, or someone who wasn't available to testify in person. I came across it once before with a witness who was caring for a sick child and wasn't able to travel to give testimony in person. And so there's quite a bit of case law that actually sets out the considerations about what needs to happen and whether credibility assessments and this kind of thing can be made effectively by video conference. That actually predates COVID and is helpful now to kind of refresh that and look back to that. Of course, it's a general rule that it's preferable for witnesses to give evidence in person, but that's not the circumstance that we have right now. That's just certainly not practical in the current situation. So we can look back to that case law. For instance, in one case, the Ontario Superior Court said that the use of video and similar technologies now has developed so much that it's not really a significant deviation from that general rule. You can see them, you can hear them, you can observe them. So the concerns that might have been present previously are not really there anymore. Similarly, as early as June of 2015, the Advocate Society did a report on best practices for civil trials. And they said the same thing, that technology, video technology specifically, has actually advanced sufficiently to allow findings of facts and decisions about credibility to go forward. So there is that body of case law that can be drawn on now when concerns about the proper format or form of virtual hearings comes up.
Yeah, and in New Brunswick, we're not assisted by an overarching piece of legislation like there is in Ontario. So I guess the first step for me, for our organization, and I guess for similar organizations, would be to look at our own governing structure, look at our act, which doesn't actually specify the nature of the hearing or how that's to proceed. That's largely delegated to the organization to come up with ways of conducting hearings as the committee sees fit, is the language in our act. And so there's room for certain practices and rules to be developed by the committee, to give adequate flexibility that way. And on the sort of more common law legalities sorts of things, I think that certainly as a healthcare professional regulatory body, but in any other really, we also have to weigh the importance of our mandate, which is to protect the public. And so while certain challenges might arise now that we haven't had before, and we're now kind of forced into proceeding a different way, we have to weigh that against the interest of the member in having a complaint heard, maybe the complainant in having the complaint heard, but also the interest of the public in having something like this determined. And I thought it was interesting in that in the Ontario Superior Court case, the comment that the mere suggestion that something may be lost as a result of a video conference hearing is not sufficient. It's possible that something will be lost as opposed to an in-person hearing is just not going to cut it anymore, at least not in today's world. So I think that that's quite helpful to a regulator in deciding on proceeding, and that it's not necessarily a matter of consent. Certainly judgment needs to be applied, but it's not a matter of everyone being okay with how the regulator has chosen to deal with the complaint.
Interesting. I'm going to throw, sorry, go ahead.
No, sorry to interrupt you. I was just going to say as well that when Melissa was talking, that reminded me in the context of interim orders is another place that I think virtual hearings are particularly important, because of course virtual hearing, interim orders, in cases where there's an interim order, it needs to be heard efficiently. It needs, this kind of toot sweet type approach. So in that case, virtual hearings can actually be quite helpful in order to make sure that, in fairness to the registrant, that their matter is being heard expeditiously, and that can really facilitate that through various virtual methods.
Okay. Is there anything that is viewed as maybe shouldn't be in a virtual hearing and should be face-to-face? And I open that up to anybody to answer. No? Okay. Anything about big evidence sharing, tips and tricks for sharing evidence? Anybody have anything quirky or different that hasn't been brought up?
But what we did in the hearing before the Discipline Committee of the Ontario College of Pharmacists is that we made sure that copies of all of the documents were sent to the panel members in hard copy in advance of the hearing. so that even though we weren't in a position to physically hand out exhibits, the panel members would have a paper copy of the documents in front of them. And I think that that made them feel a little bit more comfortable with the process. Although we were doing it by video, they still had the paper documents in front of them, and they could take notes and refer to them as they ordinarily would, and I could hold them up in front of the camera as I ordinarily would. So I think that that was helpful. For documents that we didn't want them to see right away, they were sent to them in sealed envelopes, and then they opened the envelopes on camera when we got to those documents. That's one way to approach it. In the future, when people are more comfortable with these kinds of hearings, I think that you could do it all electronically, putting all the documents on a USB key or something like that. But at least for the first hearing, we found that the panel was more comfortable having a physical copy of the document in front of them, especially in cases where if people are working from home, they might not have a second monitor or the technology that would allow them to view the hearing participants and also view documents at the same time.
I think that's a very good consideration, actually, with respect to making it user friendly. That's something that we put a lot of thought into as well when we're doing electronic hearings. And one of the things that we've come across recently, we have electronic hearing coming up that started in real life and in person and is now going to continue electronically. And so part of our question was, how do we get the documents that have already been put in front of the panel back in front of them? So we actually, I think we're going to use a shared drive, and that way both parties can put documents into the same location, so everything is there for the panel to access. And that way we can also control who has access to the documents and that kind of thing as well. And just in terms of practical, user-friendly type things for reference, when there aren't paper documents in front of them, one thing I found helpful is to color code each document. So to put the front page of every document a different color, and also to put the title, the color in the title. So instead of putting, I don't know, Anastasia's document, it would be pink Anastasia's document. And then when everything's minimized, you can see all the colors, and it makes it really easy to locate what you're looking for instead of trying to like scroll down to find the title. And it just cuts down on a lot of I guess I was going to say paper shuffling, but it's not really paper shuffling because it's all electronic, but a lot of searching. So that's kind of some very basic techniques, effective as well.
Okay, great. Chat line is burning up right now. Lots of people asking questions. Two big themes, one about technology and one about the participants. So let's just quickly look at the technology. First of all, I know you're not technical people, okay? I'm not going to ask you for a rich rev of software or putting what together, but just from a technical perspective, security issues are coming up, examples, lessons learned. Maybe Naakai, I haven't heard from you in a little bit. Do you have some thoughts on that? Oh, you're on mute there, Naakai. If you're
Sorry about
okay.
that. So, I mean, I think in terms, because of our experience right to date has been limited to teleconference hearings as well as written hearings. We have addressed some security issues, but that you would with video conference hearings. But some ways, things that we've put in place in terms of teleconference hearings is to ensure that there's a separate line for the panel in order for them to deliberate and have discussion separate from the proceeding in and of itself, and also a mechanism for them to contact and liaise with their independent legal counsel or for advice as needed. But then in terms of video conference, I think that there are some security concerns or considerations that need to be made. And I think that it may be the deciding factor in terms of why one chooses one software platform versus another. For example, are you able to lock the meeting when someone enters? Participants enter, can you lock it after which? Is there a waiting room so that members of the public that are able or want to access a public hearing can wait until the proceeding has begun? And when there are points in terms of when there's deliberation or discussion that's not open during the hearing, then you can place them back in the waiting room. use of passwords and meeting IDs. Some software have a two-step or two-factor authentication as well. And I think there's some considerations in terms of when a hearing is public, whether or not you'd post an invite on a public site, or instead you'd advise the members of the public to contact the college in order to gain access to a hearing. So those are just a few considerations in terms of security.
Okay.
And in terms of platforms, there are several. We internally for meetings, I know at the Nurses Association in New Brunswick, use Teams, but we've decided for several different functions, including hearings, to go with the Zoom for Business. And I can only speak to that platform because it's the only one we've used for a hearing, but it does have quite a long list of settings that Naakai just mentioned that you can select. And I think it's as good as the host is going to be in managing the hearing. And so we spent a lot of time playing and testing the settings, but we did have the option to turn on or off the ability for participants to record. Like you'll notice in your screen in the upper corner that Alana has this meeting being recorded. I haven't tried it myself, but I may or may not be able to record this myself. We did turn off that ability for participants at the hearing to be able to record, and they were not able to do so, but we were able to do that. We could also select whether we were going to have a cloud-based recording or local only, or no recording at all. There's a new option on Zoom to select which data centers around the globe you want to have access to or to support your call. And that'll depend, I think, on where your participants are calling from. If you're looking relatively locally, we selected Canada and the United States because we had to select the United States. That was one thing that you couldn't deselect the US, but you could deselect China, India, that sort of thing. But absolutely key, I think, for us was enabling the waiting room, so that even if someone were to say have access to the link to access the meeting, or even the password or anything else, they couldn't get into the meeting unless they were let in by the host. And then we did, I see on the chat line that the private breakout rooms were also key. And they were in fact private. We tested all that out ahead of time as well, so that people could go off and counsel could speak to the client during the hearing and that sort of thing. We could have, if we chose to, put the committee in a breakout room for deliberations. And actually we did on a preliminary matter. We had a separate breakout chat with the committee, or I did, and returned. But in terms of overall deliberations for decision, we just ultimately set that up in a separate meeting. But yeah, breakout rooms, waiting room, the data centers, and then there's also a functionality too that you can limit or not limit the ability of participants to send private chats. There were a couple of reasons why I turned that off for our hearing. One of them being that I, as the host, didn't want to have access once the recording was generated, because it does spit out the chats that were sent. Even though you can't see them during the hearing, it does spit them out afterward. And I didn't want to risk seeing anything that should have been a privileged conversation between one of the counsel and their clients. But also just in order to manage the same way you would in an in-person hearing, the ability of people to speak to one another, perhaps during testimony and that kind of thing. So that was another setting that we were able to limit the way we wanted to. Oh, and yes, there was a lock meeting option, which did work because someone dropped off and came back on and wasn't able to come in until I unlocked the meeting. So that worked too. It was a great little function.
Thank you. Anybody else?
Hi. Yeah, hi. So we actually used two different systems simultaneously for our hearing. We used a platform called Adobe Connect, which is basically like the Zoom video. And that was for the video portion only, but we used our telephones for the audio portion, and we had a teleconference number. And we also had breakout rooms. I think I really endorse what everybody said about the value of the host. We had someone who was traditionally provides administrative support to the tribunals and the panels, and that person had complete control over who came in from the waiting room, who got sent to a breakout room, The panels had a breakout room for deliberating, and I think it was very effective way to sort of move people off screen and on screen. And there were some participants like myself, I didn't really have a very active role in the hearing, and so in order to minimize clutter on the screen, I didn't activate my video. So I could see everybody and I could hear everybody, and it was clear that I was participating, but I didn't add my face to the collection of people because I didn't have an active role at that time. So I think all of that really played into it. The other thing we had was a tech person on the line with us. So the very few times that a tech issue came up, whether it was a pure tech issue or what was more common was more sort of a user error type issue, that person immediately jumped in and made sure it got fixed as quickly as possible.
Thank you. Thank you. And somebody made a comment about, you know, use your phone to videotape it and everything. I think we'd have to ask a tech person how that works and what's the quality from it. So maybe we'll have to at one point in time get some technical people on one of these virtual discussions, because there always seems to be a question. Now let's get to participants. One of the questions in the chat was, what do you do about a sensitive case and a person in a vulnerable position? What do you do with unwilling participants who say, no, I will only do this in person, or they're unprepared, or I was talking about reading CNN and somebody who decided to flush the toilet when they were on in a case. And so they're not understanding really what it means to be virtual and everybody can hear you. And how do you prepare participants? A lot of questions on managing it, the people aspect of the hearing. Just throw that one up, take it wherever you want to go, because it's a big topic, but also critical because it is all about people. Maybe Alexandra, can we start with you? Come back with you.
Yes, so for the hearing that Katharine and I were working on, as I mentioned earlier, the member was self-represented. And to be honest, when I first approached him about doing an electronic hearing, I expected that he would object to it. And in fact, it was quite the opposite. He was delighted to do the hearing electronically because he lives outside of Toronto where the hearing would otherwise be conducted. And this meant that he didn't have to travel to Toronto. So I think we'll find going forward that if self-represented members and also members who have counsel, if they live outside of Toronto or the location where the hearing would ordinarily be conducted, they may actually have a preference to proceeding electronically because it saves the time and expense of travel. So that was a bit of a surprise to me, but it certainly worked out very well in the end. In terms of preparation, the hearings department at the College of Pharmacists did do an individual test with each participant in advance of the hearing to make sure that they had the appropriate equipment and the appropriate location to do the hearing. So on the actual day of the hearing, we didn't have a delay in terms of getting everybody set up. Everybody had already dealt with those technical issues and was pretty much ready to go. So I personally haven't seen objections from participants. We have seen some cases in Ontario where it seems to be that the counsel rather than the participants are objecting to electronic hearings, perhaps because of their own unfamiliarity with the technology. And at least the courts in Ontario have not had a lot of sympathy for that. There's a case that came out just a few days ago, Conti and Smith, where Justice Myers of the Superior Court made some quite funny comments about counsel getting into 2020. And I think that objections about not being familiar with the technology are not going to fly going forward.
Anyone else? COVID has accelerated all of this for everybody. Any other thoughts, comments?
I agree. I think that I certainly would echo everything Alexandra said as well. I think another aspect of kind of managing participants is reminding everyone that it is a formal proceeding. I think kind of maintaining the formality of hearing can be quite difficult online. I think one of the things, especially on the phone, I think this can become an issue because there is a tendency to become distracted by doing other things because people they can't see you. So I think sometimes people engage in other activities and testament to the mute button. If you're doing that, definitely mute yourself, because you can still be heard. Another thing, obviously, I would encourage participants to dress as if they were appearing in person. I think that's important. Taking a minute to arrange your video so that it looks professional and you know, there's nothing in the background, minimizing background noise and distractions as much as possible. I realize, you know, everyone's working from home, so there are limitations to that, but as much as possible, maintaining the formality of the occasion, not only for, you know, for the process itself, but also in respect to the registrant who is participating. Another kind of issue which we've touched on a bit, but is the participation of the public. Some hearings are public, and so that can be quite a tricky thing of how you involve the public in an electronic hearing. There was a good article called Trial by Zoom by Amy Salazin recently that spoke, among other things, about public access and ways to do that. You know, is there going to be a link for the public? Is it going to be online? Where is it going to be for them to be able to participate or attend? You know, what level of access do they have? And I think this goes to what Melissa's saying about being able to limit functions. I think that would be quite helpful to ensure there are no disruptions, but that people can participate and attend a public hearing if they so choose. One of the concerns that was raised in the Trial by Zoom article was, since the kind of practical barriers to attending a hearing, you know, travel, arriving on time, doing all those things are limited or kind of eliminated in a lot of cases in a hearing that's going virtually. Will we see a rise in like voyeuristic attendance rather than kind of educational or typical attendance at hearings? And part of me thinks, I'm not sure that it matters why people are attending. You know, if they're permitted to do so and they're behaving appropriately, then I think that could happen in a real hearing too, or in a in-person hearing too, where people attend for, you know, not necessarily the right reasons, but they still have the right to be there. So I think that was an interesting kind of element that I hadn't really given a lot of thought to before, that was raised in that article that was quite interesting.
Anastasia-Maria reminded me of a great idea that the hearings department at the Ontario College Pharmacists had as well. And that was to provide each of the panel members with a physical screen that they could put behind their chair. So it appeared very uniform. It appeared almost as if they were all in the same hearing room, even though they were in their own homes. And that avoided the embarrassment that we've seen in some other contexts where you're looking into a member of Parliament's home or a judge's home. You couldn't see anything behind the panel members, and it really looked very professional. I thought that was a great idea.
Yeah,
that does sound like a really great alternative to the. Oh, sorry. That does sound like a great
there are
alternative.
digital. There are digital screens that you can get for Zoom, or you can take your own photo and put it up. But great idea as far as getting everybody as if they're sitting beside each other.
It is a great idea, and I think it's an even better idea than, you know, the beachscape that you can see some people put there, because I think sometimes that's a little bit distracting, and certainly it like Anastasia was saying, you should really kind of act as if you're in a hearing, and you wouldn't have sort of a beachscape behind you in a hearing otherwise. So I like the idea of having either a screen, whether it's virtual or real, behind the participants.
Okay. Anybody else? Nope. So last question. I want to throw it out because we're starting these something not in person type of hearings. And you guys even mentioned in a couple of statements at the beginning about this is not going away. COVID may be over, but really you don't fundamentally, many of you alluded to that this may be here for the longer term. What does it mean by this will stay? What do you think will stay, and what do you think is going to happen after COVID? A little bit of speculation, I guess I'm asking for you. And think about the backlog. Some people are talking about, and I just saw Supreme Court is going to hold a hearing remotely. because there is a backlog happening. Well, how do you manage that backlog? How do you choose? How do you pick your priority? And do you think they will have to scale by doing more digital? I'll just open that up. Alexandra, why don't we start with you again?
Yeah, so I think earlier in March and April, a number of organizations were simply canceling hearings to be scheduled in the hope that this would be a relatively short period of time and we could go back to in-person hearings sooner rather than later. Given where we are right now, I think that there's already somewhat of a backlog in terms of hearings that will need to be rescheduled. So some thought has to be given to how should hearings be prioritized in terms of hearings that need to be rescheduled and hearings that are already on the calendar. And Anastasia-Maria mentioned something earlier about interim orders, that in circumstances where members are subject to an interim order, colleges have to be very careful to make sure that they are complying with their duty to move the proceedings along expeditiously. So that's probably number one priority, is dealing with members who are subject to interim orders. There may also be cases where other kinds of cases where members need a hearing in order to be able to return to work. So for example, a fitness to practice hearing where a member may be able to practice under certain terms, conditions, and limitations. You may want to expedite those hearings so that the member, particularly in health professions where health professions are needed right now, may want to expedite those hearings so that members can return to work under appropriate terms, conditions, and limitations.
Thank you. Anybody else? I have to take a stab
Yeah.
at the future.
Yeah, no, I think at the outset, Anastasia mentioned one of the factors to be considered is the importance of permitting access to parties, and I think Alexandra also mentioned that one of her participants was actually quite happy at the idea of proceeding virtually because it didn't require a trip to get to the place where the in-person hearing otherwise would be. So I think that that's definitely going to be a factor for us. In some cases, I mean, we're a small province. In some cases, we've got members who are no longer in the province, but they're still an active file. And in order to gain access to employment in the other province, they have to have this one dealt with here. And so sometimes we have members who are either elsewhere in the province or they're outside of the province, or for any number of other reasons, this might actually be helpful. In addition to the cost effectiveness and maybe more efficient time management of our committee members. If we've got if we would have an in-person hearing for fitness to practice or discipline, for instance, we've got three nurse members of the committee and a public member coming from anywhere in the province. And so if we've got to have them be able to travel and all be here at the same time, we're hoping that certain matters proceeding virtually or online or as an alternative to in-person hearings, whichever way we would refer to it, might actually be more efficient in terms of getting people to be available in a timely manner to have things dealt with in an appropriate amount of time, and that might be an option going forward.
Yeah, I agree with all of that. I think trying to mitigate against a backlog is very important. Probably, I mean, it might depend on how many hearings you actually hold in a year. If you have a smaller roster, maybe you won't feel it as quickly, but if you have a large roster of hearings, I think anything that got canceled or postponed at the beginning of all of this, you'll probably see a domino effect pretty quickly. And I think that embracing as much of this as possible to mitigate against that is to everyone's benefit.
Okay. Naakai, haven't heard from you lately. Any thoughts on after
Sure, no, I
COVID?
agree with, oh, sorry, Alyson. I agree with everything that's been stated already. I think absolutely many considerations to be taken into, many things to be taken into consideration with respect to addressing a backlog. But I think the tendency to focus on just the hearing and getting the hearings rescheduled. Also, it's important to think about all the other aspects of work that happens after the hearing occurs. So you may be quick to schedule hearings back to back in order to have them occur, but then you have to take into consideration, then there are those decisions and reasons that need to be drafted. And once those decisions and reasons are drafted and disseminated if there are any compliance aspects that also need to be followed up on, should there be a finding and a penalty or a costs order, or terms, conditions, limitations, etc. So I think that's just one other aspect that needs to be taken into consideration when addressing the backlog as well.
Thank you. Just looking at some of the chat questions, we received one. What if the registrant does not have the technical resources, including computer, or there was one comment about up north, internet access might not be very stable. Who supplies this? Who is responsible for ensuring that the registrant can be heard if it's decided that it's an electronic hearing? Anybody want to offer up an answer on that?
What we've seen in Ontario is that, I guess, first of all, if a registrant is represented by counsel, it may be possible for them to use their counsel's office and facilities. If they're self-represented, we've seen in Ontario that some of the court reporters during this time have taken up getting their facilities set up so that they can assist with virtual hearings, including hearings before the court. So that may be an alternative, having the member attend at a court reporter's office to use the facilities there.
I think another consideration as well, there are obviously going to be situations where video is quite important, and then certainly the accommodations that Alexandra brought up, I think, would be the best options to look into. Another thing to consider before going into that perhaps is, is video really necessary for this portion? Can this be done by phone? Can this be done by writing? Are there other ways that we can accommodate that technological kind of gap, so to speak? Is this part really, does it need to have a video? Or and if the answer is yes, then the answer is yes, and the next step can be taken. But thinking carefully to see how what method is best, I think, is kind of the starting point.
And I think that it really is an important point that all of you have brought up. It's the alternative to in-person, and there's different ways to do the alternative. And it isn't just what we've coined as the virtual, which is the video. Another question that came up, and it's related to the legalities discussion that we had earlier. So open to anybody. It's, what about a contested hearing? Is that any different? Would you change it? Some of your processes or procedures or approach for a hearing that is very much contested? Or has anyone had any experience on that?
For contested hearings, sorry, no, go ahead, Naakai.
Oh, I was just going to say that, sorry, Anastasia, that it depends on what the matter is. Like, not each contested matter is the same. So is it a contested matter where you'll have a number of witnesses, where credibility assessment is key to the decision-making of the panel, or are there other factors that need to be taken into consideration? I think you'll have to, it's case by case, but most certainly there are contested matters that can be hearings that can be conducted via video conference, even teleconference. Just depends on what the nature of the case is.
Yeah, I completely agree. I was going to say the same thing, and I think that there may be a little bit more thought that needs to be put into how to make documents available on a contested hearing, because presumably the documents aren't, might not be going in by agreement. It may not be appropriate for the panel to have access to them in advance. They're the same considerations that you would have really in a in-person hearing. But I think there are ways and technology available to mitigate that. The use of shared drives, so that participants can, for instance, if there is a document you didn't want to be making available beforehand, can drop into a shared drive, and then it becomes available to everyone else. Or password protecting documents and making the password available in due time. So I think there is there's certainly more considerations. It becomes a little bit more complicated, perhaps, with a contested hearing. But I think for the most part, there are ways to mitigate that and to allow at least parts of contested hearings to go ahead.
Excellent. So we only have about 5 minutes left. just wanted to go across the panelists. Is there any final words that you'd like to share? I'm going to start with Melissa. We haven't heard you in a bit. Putting you on the spot, my apologies.
Without trying to repeat things that have already been said, I certainly, before the unease of proceeding with our first Zoom hearing set in, it was excitement first. It was the idea that, you know, wow, this is actually an option. We did have at the outset, but it didn't last for very long because, of course, everybody's aware of the less than positive publicity that Zoom was receiving at the outset of all of this. I do think that those things, and I'm not a proponent and I'm not technologically savvy, at least on the Zoom side of things, but I do think that we've heard, and certainly the Canadian Bar Association has been helpful in coming up with certain recommendations on Zoom and distinguishing some of those negative cases from what can be the case with hearings otherwise when you set them up properly and that sort of thing. But anyway, we were really quite excited at the notion that this might actually be an option, both to keep us going in the short term, but also going forward and how we might be able to address not only COVID backlog, but just, you know, backlog that happens as a result of any number of things, that it just may be yet another thing, another sort of arrow in the quiver to keep things moving. Because that's really always a main goal for us is to keep these complaints moving to the extent that we can, so that it's fair to all sides. Unlike a lot of regulators, NA&B is actually does not take on the role of prosecutor. So we end up having a complainant party and the member party, and we like to try to assist both in getting things moving. And so I do think that it's gonna remain part of our process. Certainly in-person hearings, we're more than set up to do those. But when a virtual hearing seems like it's going to be a good option for any number of the reasons that we've talked about in the last hour, it'll be there to stay. So I'm glad for that.
Good. Katharine, I'm just going to cover with the regulators. Katharine.
Yeah, so I would agree with. Sorry, I didn't mean to interrupt you. I would agree with all that. I think I do think that this is probably here to stay, even after you know, social distancing and all of that eases up. Whether it stays in whole or pieces of it filter into in-person hearings more frequently, but I think this is you know, the way of the future in a lot of ways, and I think that's really exciting. And so I think one of the best things that anybody can do is lots of practice. It's great to hold like a fake hearing with your colleagues at work and practice what it's like to have the number of people who are going to be on the screen and moving them into different rooms and seeing how everybody feels, and practicing, or, you know, testing, like Alex said, with the parties in advance, and lots of good preparation. But all of that pays off in the end.
Okay. And then Kai, final statements, final thoughts.
I really don't have much more to add to what Melissa and Katharine have already said, and I agree with everything that they've mentioned. I agree that this, for us, will likely be a new normal for the next little while. In terms of holding electronic hearings, our discipline committee rules have allowed for it for a while, but we've not really explored and delved into holding hearings regularly electronically. And I think that it's an opportunity to put structure in place, creating guides and tip sheets, doing the testing in advance to ensure that all parties are prepared is really important. All of which has already been said. Okay.
Well, thank you, everybody. I think we're out of time, and appreciate your support of the CNAR members and community. And very insightful. As I said, this has been recorded. We will be posting this on our YouTube channel by early next week at the latest. And obviously we have our communities of interest section on our website. And please, they're very active, and actually that's how we found out about Melissa. She asked a question into our in for some insight on as she prepared for her first virtual hearing. So thank you again, panelists. It was very interesting, especially for me. I learned something new every time. And everyone have a great day and do stay safe. Take care. Bye-bye.